Hello everyone, my name is Prajjwal Chauhan and I'm working as a legal intern under LEXIS and Company for the month of July. The topic for this video is decoding the history of sedition law in India. The law of sedition has always been one of the most contentious topics of constitutional law jurisprudence in India, with views ranging from calls for to complete abolition of the provision from our statute books to those advocating for retention of the sedition clause in its entirety with a more vigorous employment. While many others have called for the retaining the provision but keeping its implementation defined under legal limits to strike a balance between national security and fundamental rights. In the case Miss Amoda Broadcasting Company Private Limited versus the state of Andhra Pradesh and others, it was stated that there is a need to define the limits of sedition. Later, a two-judge division bench of the Apex Court in the case of Vinod Dua versus Union of India quashed an FIR, First Information Report, against the petitioner, journalist Vinod Dua, for the offence of sedition. In its judgment, the court made an observation that every journalist shall be protected from the charge of sedition, taking into account the interpretation of the offence as propounded in the court's landmark judgment in the case of Kedarnath Singh versus State of Bihar. Since the Supreme Court itself has recognized that there is need to re-examine these laws, it is important to trace the jurisprudence by Indian courts that have contributed to the present-day conception of law of sedition. Now let's talk about the genesis of section 124A of the Indian Penal Code and pre-independence jurisprudence. Many legal experts argue that the sedition clause is a vestige of British colonial rule, originally introduced to suppress critical voices emanating from the Indian freedom movement. Section 124A of the Indian Penal Code 1860, as we have today, was absent from the original draft of Macaulay's IPC in 1860 and was only introduced in the year 1870, piloted to James Stephen. This version went through further modification through the IPC Amendment Act 1899, since when it has largely retained its form. The first notable case for the offence of sedition was reported in 1891 in the case of Queen Empress versus Jogendra Chandra Bose and others, in which the editors of the Bengali magazines were charged for their criticism of the British government policies, specifically regarding the Age of Consent Act 1891. The next landmark case on this matter was that of Queen Empress versus Bal Gangadhar Tilak and Keshav Mahadev Bal. In this case, Bal Gangadhar Tilak was tried for sedition for alleged incitement through speech that led to the killing of two British officials. In this case, a single judge bench of Bombay High Court agreed with the definition of disaffection as propounded in Jogendra Chandra Bose and opined that any bad feelings towards the government is criminal, irrespective of the level of bad feelings. About 2 decades later, Tilak was again tried for sedition in the case of Emperor versus Bal Gangadhar Tilak 1917 for an article he wrote in which he advocated the attainment of Swarajya, self-rule, for Indians. In the article, Tilak explicitly admitted to loyalty to the British Crown but went on to criticize the civil services, arguing in court that the civil services and the British government were two distinct entities. A division bench of Bombay High Court rejected Tilak's contentions, holding that the civil services derived their authority from the states itself, and no ground for such distinction exists. The High Court, however, clarified that only such criticism of the civil service that can be attributed to the state should be considered seditious. Sedition jurisprudence in independent India. The case of Tara Singh Gopichand versus the state 1951 was the first instance of a court in independent India adjudicating on the constitutional validity of section 124A of the IPC. Since India was now an independent republic, constitutional provisions assumed supremacy over British precedents. The then Punjab High Court in this case recognized that Section 124 was indisputably a restriction on the freedom of speech and expression and invalidated the provision on the basis that it was a contravention to the fundamental rights of freedom of speech and expression under Article 19 of the Indian Constitution. Soon after, independent India's first parliament passed the Constitution Amendment Act 1951, which, among other things, sought to resolve the anomaly in which the constitutionality of the sedition law as a result of Tara Singh Gopichand's judgment. It did so by introducing new rules on which the right of freedom of speech and expression could be reasonably restricted. In the original constitution, the only grounds for limiting free speech enumerated in Article 19, Clause 2 were the security of the state, defamation, contempt of courts, and decency and morality. The Amendment Act introduced the new grounds of public order relating with foreign states and incitement to an offense for restricting the freedom of speech and expression. Now, invocation of the office of sedition was not confined merely to act undermining the security of state or tending to overthrow the state. It merely had to be in the interest of security of the state. Such wide-meaning terms gave greater discretion to the state to invoke the offense of sedition. The amendment was put to test within 2 years in the case of Devi Soren and others versus the state, 1954, in which the accused and Adivasi leader was booked for an inflammatory speech against the government. In its judgment, a division bench of Patna High Court made a clear distinction between disapprobation and disaffection and held that only disaffection leads to public disorder. The High Court also confirmed the constitutionality of 124A of the IPC, ruling that it does not violate Article 19. The landmark Kedarnath Singh judgment. Next, we arrive at Kedarnath Singh, which is considered the most authoritative judgment of Supreme Court on the interpretation of the sedition law. In this matter, a 5-judge constitutional bench of Supreme Court upheld the constitutional validity of Section 124A and went on to clarify the correct position of the sedition of law in India. In this case, Kedarnath Singh, who was a member of Forward Communist Party of Bihar, was charged with sedition for making insulting speeches against the ruling Indian National Congress government. The apex court clarified that Section 124A could not be used to stifle free speech and could only be invoked if it could be proven that the seditious speech in question led to the incitement to violence or would result in public disorder. Since Kedarnath criticized the Congress party and not the Indian state, and the speech in question did not lead to any incitement to violence, therefore it did not amount to sedition. Post Kedarnath Singh developments. In another important case, in the case of Balwant Singh and state of Punjab versus state of Punjab, the accused had been prosecuted for the offense of sedition as he had engaged in sloganeering in favor of an independent Sikh majority state in the wake of Indira Gandhi's assassination. A 2-judge division bench of Supreme Court ruled in the favor of the accused on the rationale that since the speech is in question does not lead to any disturbance of public order and was not likely to incite any violence in the minds of the target audience, Balwant Singh's action therefore did not amount to sedition. Courts in recent times have relied on the above interpretation in cases of sedition with few modifications. One such modification was observed about a decade back in the case of Arup Bhuyan versus the state of Assam 2011 and Sri Indra Das versus state of Assam, both of which were decided by the same 2-judge division bench of Supreme Court within 7 days of each other. In both the judgments, the court adjudicating on charge of sedition and prevention detention placed reliance on the eminent lawless action laid down by the US Supreme Court judgment in the case of Brandenburg versus Ohio 1969. As per this test, all speech is protected by the First Amendment of the US Constitution unless it incites eminent lawless action. Hence, there is an eminent need to relook the invocation of sedition under Article Section 124A and ensure that the offence is used within defined legal limits so as to strike a balance between national security and fundamental rights of the citizens. Thanks a lot for listening patiently. Please like, share and subscribe to this channel.